Good afternoon. Sorry about the delay in the start of today's webinar. Who, what, when, the estate planning edition. My name is Linda Nash. I'm an estate planning attorney here at Beresford Booth. And what I wanted to talk today was just some very simple, broad view elements of what estate planning is. There are many people who have never gone through the estate planning process and aren't familiar with some of the terms or why you even need estate planning. Estate planning generally has to do with documents that you prepare that either distribute your estate, give directions upon your death, or assist you during life. Common documents, which you've probably heard of before, is a last will and testament. That's the document that says, when I die, I appoint my executor and I want my assets to go to whomever you choose. You might have also heard of a living trust or a revocable trust that's similar to a will. It operates in the same way. You might have also heard of a durable power of attorney, either for healthcare or finances. That's a document that allows someone to step in your shoes and act on your behalf if you can't because you've been injured or incapacitated. And then you've probably also heard of a healthcare directive. It's also called an advance directive. At one point in time, it was called a living will. That's the document that says, if I'm terminally ill or in a coma, not expected to recover, this is what I want to see happen. Some other examples of estate planning that don't have to do with actually signing a will or a trust could be a community property agreement that says, I'm married to my spouse, we live in a community property state, everything we own is community property. When I die, everything goes to my spouse. If you have a mixture of community property and separate property, you may want to even have a separate property agreement that says, this is mine, this is my spouse's. There's other ways to do estate planning also that don't have anything to do with a will or a trust, such as a transfer on death deed, which we'll talk to a little bit more as we get to the end of our talk here. A lot of people may think that they don't need estate planning and that estate planning is only for really wealthy individuals who want to try to do some tax planning or tax savings. But there are a lot of reasons why you might want to consider doing some estate planning. First of all, you might think that you're not rich or wealthy, but the personal estate tax exemption for an individual in Washington state is now still just at about $2.2 million. So if you think about a married couple who owns a home, they each have retirement assets, maybe investment portfolio. Their combined estates could be in excess of $4 to $5 million, and you would want to consider doing some planning to avoid or reduce Washington state estate tax planning. Of course, if your estate is north of 5 million, 10 million, you should definitely be consulting with a estate planning attorney to make sure that taxes are reduced or eliminated. It's not just about avoiding taxes. It's about making sure that you've made the choice about all these decisions and that it's in line with what you want. I'm going to go through just three very kind of simple, pretty common examples of estate planning, which I would highly recommend for people to look into. The first one is if you are a young couple, you're married with children under the age of 18, this is your first marriage, there's a lot of considerations to be made that have nothing to do or very little to do with assets. And the first and most important thing is if something was to happen to you and your spouse, who would you want to place your children with? Who would you choose to have raise your children? This person that steps into your shoes and acts as a parent, if you will, to your children is called a guardian or a guardian of the person. They're the person that's given legal custody of the children, and they can make all the decisions on their behalf: healthcare, education, religion, where they live. And so if you want to send your kids or place your kids with specific people, you will want to have executed a will and a durable power of attorney so that the children are placed with the people you want to place them with. Um, a great deference is given to a parent's choice of guardians for their children, and the court will appoint that person as a guardian unless there is some obvious reason not to appoint them, such as they have a criminal record or something of that nature. Otherwise, if you don't have this in place, you're leaving the decision up to the courts, basically. One or more of your family members or even friends could petition the court and argue that you are the best person to be appointed as guardian for these children. And I'm sure you can imagine a scenario where your sister might be arguing with your spouse's brother, or the set of grandparents think that they would be better suited to raise your children. And not only is this messy and expensive, you're leaving it up to the discretion of the courts, who's going to make the best decision they can for the children. But if you could name your guardians ahead of time, all of that messiness is not necessary. In your will, you would also select a trustee to manage any assets that you might leave to your children. So there's two roles here. One is the guardian of the person, and then the other one is who would be in charge of whatever assets are left for the children. This could be very important if your children are young and this person's going to be a trustee for a while, and they're going to have to manage it, invest it properly, make sure there's enough in the trust to provide for college or for health needs. Sometimes the trustee can also be the guardian. Sometimes they're different people. But again, if you don't choose this, the court is going to choose this for you. And they may choose the same people that are the guardians. They also might choose a completely different trustee to manage the assets. What I've been talking about a great deal has to do with if both you and your spouse are deceased and your children need to be permanently placed with and cared for. There is another type of a situation where perhaps both you and your spouse are injured in an accident, and your children need a temporary guardian. You would nominate such a person under your durable power of attorney instead of your will, because as we've stated, your will takes effect when you pass away. Your durable power of attorney is in effect when you are while you're alive. So if you are temporarily incapacitated, if something happens to your spouse but you are ill, there's somebody appointed to step in, again, that you have chosen to take care of your children. So that's why I highly recommend married people with young children to have some sort of estate planning in place so that your choices are honored, and so that the children aren't in the middle of a messy fight. The second type of estate planning I think is important is for single people. Now, this would be whether you're single with no children or single with children. But when we don't have a spouse to nominate and step in to handle our estate or make healthcare decisions for us, we want to make sure we name somebody. And it could be that you are single and you have several siblings who might want to step in and make these decisions for you. Or you could be single and you have children who would want to step in and say, I want to make decisions regarding mom or dad's healthcare or finances. Well, if you haven't chosen these people ahead of time, again, this leads to a lot of discrepancy and argument, and that choice is out of your hands. So if you as a single person, create a will. You designate who in your family or a close friend is going to be the executor. And then under your durable power of attorneys, you're going to nominate, again, family member, close friend, to step in and help you make healthcare or financial decisions if you are injured or incapacitated. And then also, if you do not have a will, which is true for anybody, not just single people, the state statutes step in and say this is where your property goes. We're going to talk a little bit more about this on the next slide, but as a single person, you may say, "Oh, well, I'm okay if my assets go to my siblings or to my kids." But maybe you don't want that to happen. Maybe you want your kids to be cared for, but you want those assets to be held in a trust. Maybe you want everything to go to a charity. If you don't put that in a will, those wishes and intentions are not going to be honored. The third kind of category is families that are blended families. It's a second marriage, so both spouses have may have children from a prior marriage, and they might also have children together. They may have come into the marriage with separate property. They could both have community property and separate property at the same time. So it's not just as simple as if I pass away, everything just goes to my spouse, because you could have separate property that the deceased spouse's children may be entitled to. And that may not be what you and your spouse want. A common goal with all wills with spouses is that, generally speaking, we want to take care of our surviving spouse. But does that mean leaving all of my estate to my spouse, and then she can do whatever she wants? Or do I want to leave those assets in trust so my spouse can use them? But then when she passes away, those assets can go to my children or to all of our children, including stepchildren. None of those decisions can be made unless you've put that in writing in your will or your trust. The difference between separate and community property, it can be significant if you don't have a will and you do have separate property, you have children from another marriage, or if you're single, your assets can end up going to relatives that you just never intended for those to go to. Within the second marriage blended family discussion, you may need to get into a more detailed discussion about whether you need a prenuptial agreement if you're getting married, a postnuptial agreement. Do you want to just say everything is community property? So those are discussions that you would have with an estate planning attorney that you went to as a married couple. There are other ways to dispose of your estate without having a will. You could have a community property agreement. This may make sense if you have lived in Washington your whole life, you and your spouse got married here. You don't have any significant tax planning to do, and you just want everything to go to your spouse upon your death. You can execute just a simple community property agreement. There's also something called a transfer on death deed, which basically you can just leave your house, your real property, to whomever you want upon your death, and thereby you avoid probate and you don't need a will. You could do the same through beneficiary designations on your life insurance, your investment accounts, or your retirement accounts specifically. There's also survivorship accounts. Most spouses will have a bank account joint with right of survivorship, meaning that when the first spouse passes away, the remaining spouse just holds the account and they don't have to go through probate. So these are all very valid and valuable methods of estate planning. But what you want to do is consider all your options. Is it appropriate for your family, your goals, and your assets? And if estate planning is for everyone, why isn't everyone getting this done? Well, there's a lot of roadblocks to getting your estate planning completed. Um, to have to sit and talk about what's going to happen upon your death can be very uncomfortable and for a lot of people, especially if you're talking about you have minor children, and what if you and your husband were involved in an accident tomorrow? What would happen to your kids? That's the point of the question. But it also leads you to, well, that would be terrible, and that my children would uh, it would be awful for my children, and I can't imagine that happening. And so you do have to deal with and approach some very difficult issues. Same thing to be said for your documents like your healthcare directive. If you have to consider, if I'm in a coma and I'm not going to survive and I withdraw life support, um, you know, what's you suddenly imagine your children around you and what that would look like. So we need to acknowledge that these are uncomfortable situations to talk about, but the alternative, and there's always going to be something. It's either going to be you make the plan ahead of time, or the state comes in and says what's going to happen. Something is going to happen. Um, and it's better that you have made this decision and discussed these outcomes ahead of time. For many estate planning clients, choosing a guardian, one person over another relative, can be, I don't want to hurt somebody's feelings. Same if you choose to distribute your estate unequally, that you want to be sensitive to how other people are going to feel about this, even if you went so far as to disinherit a child for whatever reason. And that is, again, a very real type of a feeling. Your estate planning documents are yours and they're confidential. If you were going to appoint guardians for your minor children, we would always recommend that you talk to the people that you've nominated, make sure that they're willing to take that on, and let them know if something happens. Go find our estate planning documents and you will be the guardian of our children. But other than that, you're not required to share anything with anybody. And again, this all comes back to being your choice. And you can choose to discuss your choices with your whole family, or you can say this has been taken care of. A lot of people just don't seem to think that anything is going to happen to both of them at the same time, which we all know is not necessarily true. So we want to plan for every scenario, which could include the potential of a married couple being involved in an accident at some point and both of them passing away at the same time. And many people for many years have thought, if I'm married, everything just goes to my spouse. I don't have to do anything, which is generally speaking true. But it depends on what type of assets you have, and whether how you're going to proceed with administration of probate. So you're still going to have to take steps after your spouse passes away that are still going to have to be taken to transfer property, etc. And we see a lot of problems when married people, one spouse dies and the other spouse does nothing. And then when the second spouse dies, title has not been changed, accounts haven't been updated, beneficiaries haven't been updated. So while a married person is entitled to receive all of their spouse's community property, if you don't have a will, you're still going to have to take some steps. So this is why we believe as estate planning attorneys that that everyone should at least consider what type of plan they might need for their family, for their goals, and to make sure that their choices with regard to their children, their spouses, their assets, and their health are all in place and honored. So if you have any questions, my name and phone number is up on the screen. We'd be happy to discuss this with anybody, and have a great day. Thank you.